is a person's personal law? A person's personal law may be defined as that which attaches to him wherever he may go, the law that generally governs his status, capacity, condition, family relations, and the consequences of his actuations. It may be his national law, the law of his domicile, or the law of the situs of the event or transaction wherein he was involved, depending on the theory applied and enforced in the forum. Distinguish status from capacity. Status is the place of an individual in society and consists of personal qualities and relationships, more or less permanent, with which the state and the community are concerned. It includes the civil status of a person, whether he is single, married, widowed, or divorced, his paternity and filiation, whether he is legitimate or illegitimate or adopted, whether he is a minor or has reached the age of majority, whether he has the capacity to enter into various transactions. It also includes his name, sex, and his profession, in certain cases, whether he is a lawyer or a doctor or a judge or an appellate justice or whatsoever. Capacity, on the other hand, is only part of one's status and may be defined as the sum total of his rights and obligations. Under our civil code, there are two kinds of capacity: juridical capacity, or the passive capacity, which is the fitness to be the subject of legal relations, and the capacity to act, or active capacity, which is the power to do acts with legal effects. For example, a baby has juridical capacity, but it has no capacity to act. What are the characteristics of status? First, it is conferred principally by the state, not by the individual. Second, it is a matter of public or social interest. Third, being a concept of social order, it cannot easily be terminated at the mere will or desire of the parties. Fourth, it is generally supposed to have a universal character. When a certain status is created by law, it is generally recognized all over the world. State the different theories on how the personal law of an individual is determined. First, the nationality theory, also called the personal theory, by virtue of which the status and capacity of a person are determined by the law of his nationality or his national law. Second, the domiciliary theory, or the territorial theory, by virtue of which the status and capacity of a person are determined by the law of his domicile. Third, the situs or eclectic theory, by virtue of which the law of the particular place or situs of an event or transaction is the controlling law. What theory does the Philippines follow? What about the United States? In the Philippines, we follow the nationality theory. In the United States, like other common law countries, it follows the domiciliary theory. Is personal law the same as national law? In countries that follow the nationality theory, like the Philippines, yes. However, in countries that follow the domiciliary or eclectic or situs theory, no. Is national law the same as the law of one's citizenship? In other words, are a person's nationality and citizenship the same? Nationality refers to membership in a political community, one that is personal and more or less permanent, not temporary. A citizen, on the other hand, is one who owes allegiance to and is entitled to the protection of the state. In the field of conflict of laws, however, nationality and citizenship are the same, or national and citizen are the same. When our law refers to one's national law, the law means the person's law of citizenship. Thus, the national law of Filipinos is Philippine law, while the national law of an alien is the law of his citizenship. Once a Filipino citizen, however, is naturalized in another country, his national law already becomes the law of his new citizenship. A former Filipino citizen, once naturalized an American, is now an American citizen, and his national law is now American law. What are the reasons why some countries adopt the nationality theory while others adopt the domiciliary theory? Civil law countries like the Philippines follow the nationality theory. In such countries, the nationality theory has been considered justified on practical considerations of convenience and expediency. The people of these countries are considered bound by a spirit of national unity, by common history and mores, so that identity and legal position of their citizens are guaranteed by the consistent application of their national laws on status and family relations wherever they may go and even when they migrate to other countries. The domiciliary theory, on the other hand, assumes that the attributes which make up one's status and personal relations are intimately connected with the country where they have made their home. It is adopted by the United States and other common law countries whose populations consist of people of different nationalities with varying traditions, culture, and ideals, and whose unity may be considered achieved by adopting the law of their domicile as the law that governs their status and family relations. Countries with mixed population brought about by the migration of foreigners to their shores need the domiciliary principle to attain certain fusion of their population and to avoid the necessity of applying different law to practically every case.